I'm Rob Natelson. I'm Senior Fellow in Constitutional Jurisprudence at the Independence Institute in Denver and formerly Professor of Law at the University of Montana. What is the extent of Congress's power over Indian affairs? In my article, The Original Understanding of the Indian Commerce Clause, an update, published in Volume 23 of the Federalist Society Review, I contend that the Constitution empowers Congress to regulate commercial transactions and relationships with Indian tribes, but that this power does not extend to family law. During the October 2022 term, the Supreme Court will decide Brackeen versus Haaland, a challenge to the constitutionality of the Indian Child Welfare Act. That federal statute regulates the home placement of Indian foster and adopted children. Challengers argue that Article 1 of the Constitution does not authorize Congress to regulate the placement of Indian children, but rather leaves that subject to the tribes and the states. Defenders of the Indian Child Welfare Act claim Congress had power to enact it because of the Indian Commerce Clause. That's the part of the Constitution's Commerce Clause that grants Congress power to regulate commerce with the Indian tribes. But several studies of what the founders meant when they adopted the Commerce Clause have concluded that the clause grants Congress only administration of the body of law they knew as the law merchant. The law merchant included such subjects as the goods traded, the conduct of merchants, and commercial finance and navigation. Even the Supreme Court's modern expanded commerce power jurisprudence respects this understanding by limiting Congress's commerce power to activities that are economic in nature. The law's defenders respond that the founders had a much broader understanding of the word commerce when applied to the Indian tribes than when applied to foreign nations or states. They note that during the administration of President George Washington, the federal government exercised very broad power over the Indians. But we generally presume that a single word within a single document, in this case, commerce, does not change meaning that way. In the case of the Constitution, this presumption is strengthened by the document's Port Preference Clause, which uses the phrase regulation of commerce in its traditional economic sense. My article examines the claim that commerce has a broader meaning when applied to Native Americans than in other contexts. The article finds that the meager evidence raised to support the claim does not, in fact, do so. I also point out that the broad Indian affairs powers exercised during the early Republic usually derived from parts of the Constitution other than the Indian Commerce Clause, such as the Treaty Power and Territories Clause. None of those latter provisions are relevant to the Indian Child Welfare Act. The article concludes that the Indian Commerce Clause does not empower Congress to regulate child placement.